Welcome to the 7th IEL Collective Conversation. I'm Paolo Vargiu from the University of Leicester, and today with a very nice partner, we're going to discuss a recent blog post we put on Medium on international investment law and the COVID-19 pandemic. The reason why we work on that blog post is because the effect of the pandemic in terms of investment claims have been a subject of a massive amount of blog posts on various platforms, none of which were particularly concerned with issues like equality, wealth distribution, or living conditions in affected states. So this led us to try and address the problem for a more comprehensive perspective. And in this conversation, we will try and concentrate what we did with our work and the most interesting reactions that we had on Twitter and Medium. So we have, as I said, a rich panel of speakers today, and I will let the speakers introduce themselves. Perhaps start with Anil.
Okay, hi, thank you, Paolo. So my name is Anil Yilmaz, and I'm a lecturer at the University of Essex in the School of Law, and I'm the co-director of the Essex Business and Human Rights Project. And my research focuses on the intersections of international investment law, human rights, and business and human rights. Thanks.
Jean?
Hi, I'm Jean Ho. I'm Associate Professor at the Faculty of Law at the National University of Singapore. I work on state responsibility, investor responsibility, treaty interpretation, and I convene a course, International Investment Law and Arbitration.
Thank you. And then we have our guest of honor, Professor Sornarajah.
My name is Muthucumaraswamy Sornarajah. I'm an emeritus professor at the National University of Singapore. I teach public international law. I used to teach public international law and continue to teach international law and foreign investment at different universities. Thank you.
Very well. I guess that makes it for introductions. We can kick off. And Anil, perhaps you'd like to start by giving us the general framework of the article.
Okay, thanks. Thank you, Paolo. And it's great to have Professor Sornarajah here today with us. So we've been thinking about, several of us in the IEL Collective, about the impact of the measures that states have introduced since the start of the COVID-19 pandemic. And we have seen unprecedented measures, obviously, that states have taken to tackle the spread of the disease and also tackle some of the economic and social impacts of the measures and the disease. And so these range from lockdowns and travel restrictions, nationalization of private hospitals, export bans on essential drugs or personal protective equipment, medical equipment. We've seen furlough schemes being introduced in states, in various states, different types of income support measures. We've seen school closures. We've seen FDI screening measures being introduced. And so we've been thinking about how these measures has been impacting businesses as well as everyone in the society, basically. And how, like several other people have discussed this in various blog posts, how these measures could give rise to investment treaty claims or investment contract claims under international investment law. And so I think we then started thinking about, personally, I see it as, this is a really clear indication that what we see happening is that international investment law isn't so much about non-discrimination and fairness, but it's more about privilege. And I think the impact of the measures and the availability of remedies to various parts of the society for their grievances, I think demonstrates very, very clearly that international investment law can be seen more as a privilege rather than as a mechanism of non-discrimination and fairness. And I think we wanted to really highlight that in the article to demonstrate how in all these discussions that scholars are having about potential investment treaty claims, potential state liability, there is a very clear focus on, what are the defenses and how could states get out of this. But I think we have to look at it from a more all-encompassing point of view, thinking about different groups in society who are impacted from these very restrictive measures, both economically and socially, and how many individuals, families, workers affected will never have any compensation of their losses. Whereas international investors, or those businesses that qualify under international investment law as investors, will at least have a go at investment treaty claims. So we don't know what the outcomes will be. But if we look at what has happened in the past, in Argentinian claims or in other investment treaty claims, I think it's safe to say that there is a real risk that states will have to prioritize compensating investors under the investment treaty regime rather than focusing their attention, as they should, to protecting vulnerable citizens in their communities. So I'm going to leave it there, and then we can continue.
That's a very interesting point. I was wondering whether Jean wants to chip in on the international investment regime and how this is going to be affected.
Sure. So it was, the four of us got together and wrote this blog post, which turned out to be a very long blog post. I think we covered a lot of ground, and we covered both foundations and we covered international investment agreements as well. So the investment regime that we have today is one that is largely, I would say, governed by the thousands of bilateral investment treaties in force. We understand, of course, that the intra-EU BITs are being terminated, but that doesn't mean that BITs are gone. It doesn't mean that IIAs are gone. International investment agreements, we still have lots of them around. And I think one point of focus in recent times has been how we can change these treaties for the better. Because the criticism, right, of your first generation treaties is that they tend to be very vague. So your protection standards can be interpreted in any way. And one of the trends that has been observed is that the standards of treatment, for example, you have fair and equitable treatment, you have full protection security, have been interpreted very expansively in favor of foreign investors. So that, of course, has led to a backlash against investment treaties. But we don't see investment treaties disappearing. We see instead second generation treaties emerging, whereby these standards are drafted in a more circumspect fashion, some may say, because there are lots of qualifications as to when you might be eligible for treaty protection, and there are lots of qualifications to otherwise undefined treatment standards as well. So what we have chosen to focus on in the blog post is defenses. Because, well, in sort of to engage with the work that's out there on the potential for an avalanche of investor claims against states after COVID-19, there is a lot of optimism that the defenses in these newer generation treaties will be a sort of safe harbor for states, in that once, well, if there's a pandemic, you can invoke the public health exception quite easily. Or you may even be able to invoke the national security exception as well, if there isn't a sort of explicit public health exception in the treaty. And we wanted to take issue with that because it seemed too easy. And once you take a closer look at the treaties, it confirms that it's not that straightforward. So we did take a look at a lot of the treaties, although we only dealt with one in the blog post. But suffice to say that even in the most permissive newer generation treaties, or those which are supposed to be more respective of the state's right to regulate, they require a balancing exercise to be conducted. So on the one hand, you can take a measure to deal with the pandemic, but on the other, in order not to fall afoul of your treaty obligations, that measure has to be balanced against investor rights. At this point in time, no one really knows how that balance is going to be struck, but I am somewhat less optimistic than the other pundits out there who believe that these exceptions and defenses found in your newer generation treaties are a sort of salve or comfort to states in times like these. And I think there is a lot of uncertainty as to how these treaties will actually be read, and when push comes to shove, how they are going to be interpreted by arbitral tribunals, which is perhaps why a moratorium has been suggested very recently by various bodies. Columbia Center for CCSI has suggested a moratorium on investor claims. We also have a proposal from IISD along those lines, which is to suspend the operation of investment treaties for the time being, which is a lot like a moratorium. So there is a lot of doubt surrounding the ability of these agreements to, protect investors on the one hand, and allow states the leeway to do what they had to do in a pandemic on the other. And lots of people are not extremely confident that sort of balance can be well struck, and certainly not struck in favor of states. So it's a piece, I think, which is critical of the current regime. But I think it's better to acknowledge where we are right now and what we have in order to figure out what to do next, than to pretend that everything is all right. So yeah. So I think I have other comments I'll make later. Thanks.
Well, I mean, that's certainly a problem, the fact that we can criticize and provide as much critique as we can of the system, but I mean, I don't want to be too pessimistic and say the system is here to stay or the regime is here to stay, but certainly it's not going to go away just as a result of the pandemic. And whatever consequences the regime might have will probably be exacerbated by the consequences of not even the economic crisis, just the measures taken by states and corporations alike, unfortunately. But I was wondering whether now it's probably the time to gather the thoughts of Professor Sornarajah, who wrote pretty much more than everybody else on the regime. So he might have a clearer picture than us.
Well, I agree with everything that was said in the paper, except that I do not think that there would be an avalanche of litigation following COVID-19, because of the fact that most of the investors who are involved would want to continue with their investments, recover them as fast as possible, rather than antagonize the host states in which they operate. The Argentine situation was different because the Argentine investors were leaving the state and they wanted to grab as much as they could. And perhaps that was the case with the world economic crisis in 2008 as well. We did have a few cases. Of course, the Spanish cases are also slightly different in the sense that there the investors wanted to continue. They still had profits. And of course, we also see that the cases did not all go the way the investors wanted. So pretty obviously, the investors affected by the COVID measures would not want to attract opprobrium in the states that they would function by bringing arbitration against the host states in respect of measures which their own home states would have taken. After all, what are the measures that are being taken? Whatever state takes those measures, they're vastly similar, whether it be in the United Kingdom, in China, in Sri Lanka, or elsewhere. So we have to look sector by sector. What are the sectors that would be subject to a large number of arbitrations? I was in Sri Lanka recently, and my thoughts were on Sri Lanka largely. Much of the investments there are in tourism, large hotels are run by foreign investors, would they bring actions? I mean, it's very unlikely that they wouldn't want to. Rather, they would want to come back in and pursue their interests in the hotels that they have constructed. The most likely situations in which there is going to be arbitrations would be in the area of sovereign bonds. Sri Lanka, we saw, is a debtor nation, has a lot of sovereign debts, and here we might see the abaclat type of situation in which there could be arbitrations. Another source, of course, would be patents, violation of patent rights in respect of medicines. But before that happens, before Sri Lanka violates any patent rights, there would have been other countries which would have violated patent rights. And this would be pretty common worldwide. So my first idea simply is that, I think we are making too much of this idea that there would be a flood of arbitrations following the COVID-19 measures. Second, I think that if they do happen, it would only hasten the disintegration of international investment law, which is a process that has already begun. We can't discount the fact that the most significant aspect of investment treaties, namely the mechanism of arbitration that ensures the enforcement of the law, that's getting displaced. I mean, the Europeans are going to have a court. The RCEP, all of the states agreed on not having arbitration. So we do find that there is a dismantling of investment arbitration, despite the efforts on the part of Anil to tinker with it by saying we are not going to have triple hatting and we are going to dispense with some of the faults in procedure of arbitration. They have not been able to replace the substantive law, which is what most people are concerned with. So there's no effort to reform that. And as long as that remains unreformed, there would be a lot of resistance. We see that in the Indian treaty and perhaps even in the US CMA, where you find a greater emphasis on denial of justice as the basis for liability. As regards the defenses, I do agree with that, and I think I've written on this too, and I've said that the balance treaty is no balance at all, because you can never balance the sovereign right of a state to protect its public interests against an investor's rights, which are in the hierarchy of rights right at the bottom. I mean, you have international community interests in climate environmental protection, in human rights. These are all precedent rights. And then, of course, there is the public interest of the state itself. All these are precedent rights over the rights of the protection of the investor. So in that sense, if there is to be a treaty, and I think I've written a couple of pieces on this, and a new piece is going to come out in the Journal of International Economic Law. If there is to be a new treaty, it must start with the right to protect the public as the most significant right, and that the exception should be the protection of the investor. The exceptional situations being those which are allowed in customary international law for the denial of rights, for discrimination, racial or otherwise, and possibly for the failure to provide appropriate compensation as there is adequate authority for it. Thank you.
There is a lot of food for thought here, and I would like to put some things in order so that we can proceed with covering all these points. I would like to say a few words on this very last point, the right to protect the public as a rule and the investor protection as an exception. One of the things that prompted us to write that blog post was, at least from a personal perspective, but I think I shared this with the others, the fact that a lot of the contributions that have been proposed were theoretically neutral. they were written from a perspective of, this is the law, there's nothing we can do about the law, so let's just try and understand what's going to happen with the law as it is. And in fact, we can actually argue that if somebody looks neutral, acts neutral vis-a-vis international investment law, it's not a neutral position. It's a position of somebody who's okay with the system, or with the regime, call it what you want. And this was the annoying feeling, the bizarre feeling that I had at times was that some of the contributors, and these were actually smelling blood, instead of like thinking that there won't be an avalanche of arbitrations, as Professor Sornarajah just pointed out, they sounded like they were hoping there would be a lot of arbitral cases going on, because it's going to be a lot to write about, it's going to be a lot of appointments flying there, it's going to be a lot of interest being shut off. And that's, again, something that worries me quite a lot. On another point that Professor Sornarajah just raised is the fact that investors will try and keep the system flowing as much as and as well as they can. So arbitration might not be in their best interest. So I was wondering, Anil, whether you see a increase in business and human rights concern rising out of this.
Thank you. I would like to, I'm a bit surprised that Professor Sornarajah is so optimistic. I wish I was that optimistic about possible claims. I hope that there won't be, but we've seen again and again how investors, and not investors maybe, but their legal advisors can be so creative to find interesting ways of bringing investment treaty claims. So one of the sectors that that could be a potential is airline sector. I'm sure some will receive bailouts from government. So many businesses that are affected by this will receive government support, different types of bailouts. And they probably have more financial cushioning. I mean, some may not, but some will have reserves that will keep them going for a while. But they will have, many governments will end up prioritizing saving the big businesses because they are always too big to fail. And so there is going to be that. But I feel like some businesses will want to top that up with investment treaty claims because they might think that that's not enough what they get. So yeah, you know, medical patents and maybe private hospitals, maybe sovereign bond claims could be brought, and there could be others that we can't even imagine right now because we're not thinking as creatively as investment lawyers do, maybe, I don't know. So that was the point on that. And the other thing that Professor Sornarajah said was most states are taking similar measures. And that's true. Most states are introducing lockdowns or other restrictive measures that we're seeing happening in many countries. But again, looking at past claims, I feel like investors are always looking for the discrepancies between the types of measures that states are taking. So they might not challenge that states are introducing these measures per se, but they might say, look at South Korea. South Korea hasn't entered into, you know, a lockdown or it hasn't introduced as restrictive measures as the UK has done or some other country has done. So there may be comparisons like that and maybe arguments that states could still protect public health, but without introducing these extremely restrictive measures. So the balancing act that may be done or may be expected by investors or may be carried out by investment arbitration tribunals could be different than the way we view what is necessary in a situation of a pandemic like this. So going back to Paolo's question about business and human rights implications or issues, I think, again, going back to the right of states to to protect the public interest. So if we look at that from a human rights perspective, it's a duty and not just a right. So states have a duty to protect human rights and protect human rights of their citizens or of those persons that are present in their territory from actions or violations that may be committed by private parties like investors or other businesses. So I absolutely agree that we need a different framing of foreign investment governance, and that it should be the rule, and it is the rule in the universe of human rights law, that states have a duty to protect, and that is a central duty. But when we look at investment law, public interest is very marginalized in the investment law scholarship or investment arbitration awards. So there is a disconnect there. So I think it would be great if investment law could be, reconstructed in that way. And there are other business and human rights implications, some of which we did address in the blog post, in terms of employers' responsibilities towards their employees, health and safety during the pandemic. And investment law doesn't deal with these issues. Investment law is, again, blind to the obligations of investors that exist in the sphere of business and human rights, but they're not being perceived in the investment law scholarship. I'll end it there.
Speaking of which, this actually connects back to the point that Professor Sornarajah raised about the fact that the dismantling of arbitration has already started, but until we have a reform of the substantive law, nothing really is going to change. And I was wondering, Jean, in our circles, let's call it like that, the discussion seems to be all day, every day about the reform of arbitration, but there is very little talk about reforming substantive law at the moment. How do you see that?
I think that's deeply problematic. I think, as we alluded to, I think we either specifically said it or we alluded to in the blog post, the current reform campaigns, I think they scratch at the surface. So everyone knows that there is a problem, all right, but there are very different ways of framing the problem. So what we see is a great focus on procedural matters, which at the end of the day, in my view, even if you sort that out, it doesn't change the disillusionment with the system. It's not going to make it go away. So those are not the cures to the system. But substantive reform is extremely difficult to achieve. And I think, I'm not sure, but I think it makes you unpopular if you say that you are for substantive reform. This is an area that I'm currently working on, which is investor responsibility under international law, and I don't think it has received enough attention in the past because we have been so focused on engaging the responsibility of states that sometimes we overlook misbehaving investors as well. And it's obviously not a binary situation, right? Because we understand right now that the foreign investment relationship involves multiple actors. It's not just investors on the one end and states on the other. Another very large and important group, which has until very recently been largely overlooked, is indigenous communities and local communities, vulnerable communities. So there is emerging scholarship on that, which is very reassuring. But substantive reform, I feel it's not something which many people feel very comfortable engaging in. I don't think it's fair to sort of put that on the shoulders of a few people and say that, well, I mean, if you guys were for substantive reform, then something will get done. Because there doesn't seem to be that much interest from the states at the UNCITRAL working group session to put substantive reform on the agenda. That's the impression that I have. So if the major players in the system, the states, are not quite on board with this idea of substantive reform, it makes it much more difficult to push through. So I don't suppose this is a surprise, given how history has unfolded. The Exit Convention is one which focuses on procedure, because that was the only thing that the states were able to come to an agreement on. So anything that was substantive in nature was expunged from the agenda. So that's why we have an Exit Convention that looks the way it does today. It's much easier to secure agreement and consensus on procedural matters. And for that reason, I understand why the UNCITRAL Working Group is moving in the direction that it is. But with the pandemic, and whether or not we have an avalanche of claims, I hope we don't. But I must say I'm with Paolo on this point. I'm actually quite cynical, because Paolo did say that that I think there's some who will be quite happy if there are an avalanche of claims. And if you take a look at a lot of the blog posts that have been written, they're almost handbooks for investors, what to do when you bring a claim, so what are your heads of claim going to be, and how are you going to make your FET argument, for example? How are you going to make your expropriation argument, for example? And that, I think, is a way of encouraging claims. So maybe if not for those little handbooks, perhaps there won't be an avalanche of claims. But the more and more you see these handbooks, in 3 or 4 pages, you might get the idea that, hey, maybe we could try and sue under a treaty and see what happens, you see. Sometimes somebody has to plant the idea. And we see lots of this idea being planted everywhere right now in a lot of blog posts. So I certainly hope that we don't see an avalanche of claims, but if we do, I wouldn't be in the least surprised. So with that in mind, if we're going to be seeing claims, and if we do see mass claims in sovereign bond cases, and we see other claims in patent violation cases, well, these are investor claims nonetheless, it will put the system to test. And I think it makes it much harder to avoid the need for substantive reform. The way I see it, we've shelved it long enough, and I don't think you can hope to have a fairer investment regulation regime if you keep putting off the question of substantive reform. There are things you can defer, but you can't defer it indefinitely. And I think if the pandemic is going to either speed up the disintegration of international investment law, or really force us to think about substantive reform. Thanks.
And I was wondering, as somebody who has engaged with the necessity for reform for a very long time now, Professor Sornarajah, do you think it's likely that we'll actually see some reform in substantive matters, or are we right in being pessimistic and nothing's going to change for a long time once again?
Well, I don't. When it comes to reform, I see a lot of reform. I don't see entrenchment of old rules in this area. We see states like South Africa leaving, states like India, an important country, having a new model treaty that is very restrictive, recognizing corporate state responsibility, and all manner of new ideas flow through it. So there is change, no doubt. And the task of younger scholars, I believe, should be to facilitate such change rather than think about their own comfort zones. Think about whether states will bring about change or not. Individuals bring about change. It's not states that bring about change, but individual scholars, individuals in different countries, their thinking, their writing, that is what brings about change. So I don't believe that that this idea that, UNCITRAL is only thinking about procedure is something that younger scholars should buy into. They should boldly confront this problem, that it is based, it's a system that is iniquitous, is based on inequality, that it is a system that must be displaced, dismantled, and new structures put in its place. We see that history is replete with this idea of diverting concern from substantive areas of the law into peripheral rules of procedure. We see that in state responsibility, particularly. And you have the rapporteur saying that he's drafting rules on secondary responsibility. And thereafter, of course, you find the rules of primary responsibility being filled in by tribunals on the basis of the authority provided by the secondary rules. It's an age-old device, a Trojan horse of Western international lawyers that we should not succumb to. We should not be worried about the consequences it has for us. Maybe we won't get good scholarships or grants or whatever it be. I did not. But you have to be honest with yourself and say that this is the change that is desirable in this area and work towards it. You talk about a circle that you have, and please do convince that circle that they should work towards change in the substantive law, which is very unfair. But, even if you look at the existing substantive law, it's not likely that all the claims that are going to be brought are going to succeed. To a large extent, of course, it depends on the constitution of the tribunal. You look at the Spanish cases that are coming out, you see that there is an equal division, and there's always a dissenting arbitrator. There is a great amount of dissent that is being generated, whereas in the old days that would not have happened. So in this sense, then, there is something that's happening out there. And if there are a large number of COVID cases, then we should try and sort of state the opposite view. I mean, is it a legitimate expectation? Is there indirect expropriation? I mean, I don't agree with Anil that you would be able to make subtle changes, because after all, the changes have to be so subtle that they have to be recognized as possible basis on which to plug a particular award. So my own view is that if there is an avalanche of cases, there should be a lot of writing trying to sort of desist the innovations that are being put in. Like, for example, legitimate expectations, there's no authority for it. And now we see that the arbitrators are trying, some of them at least, are trying to whittle down the scope of legitimate expectations. So to that extent, then, the writings of individuals have had an effect on substantive law, even when it comes to the making of arbitral awards. So my view is that we should confront this head on and not be subverted by the fact that discomfort would arise if we were to challenge the views of the powers that be that control the law. Yeah.
Well, I have to say, these are beautiful words of hope and resistance. And I think we couldn't possibly hope to close on a better note. Before we wrap it up, I think it's due that we say hi to our co-author, Daria Davitti, who can't be here today with us because of her parental commitments, something that is disproportionately affecting female scholars in terms of a pandemic, and possibly something that we will have to address in a future IEL Collective Conversation. In the meanwhile, I would like to thank Professor Sornarajah for being here with us, and my co-author, Dr. Jin Ho and Dr. Anil Yilmaz. And thank our audience for the attention. Please subscribe to the IEL Collective channel. The link must be somewhere here on the screen. And if you want to read our blog post that we talked about, the link is on the description here on YouTube. We hope to see you again on these channels, on Twitter, on social media. And for now, thank you very much, everybody.
Goodbye.